Reading a lot of bad information about the recent 132-page order dismissing counterclaims filed by Justin Baldoni against Blake Lively. Now, I handle a lot of internet defamation cases, especially high-profile ones, and I'm going to break it down for you. This is a complex subject, and I'm going to move very quickly, but here we go. Now, this is from the actual order by the judge, and this is a great summary. Justin Baldoni, which is the Wayfarer Parties, that's the name of his company, filed a lawsuit against Blake Lively, Ryan Reynolds, Sloan, who's their PR specialist, and the New York Times. It was a separate case, and then it got consolidated, so essentially his claims became counterclaims. And he made sort of two categories of claims. One is this first category discussed above, where he alleged that basically they conspired to take control over and take credit for the film. And number two, second category, is really that Blake Lively, Ryan Reynolds, Sloan, and the New York Times basically defamed Baldoni by spreading a false narrative that Justin Baldoni committed sexual misconduct and then engaged in an organized smear campaign. Those are the two buckets we're talking about in terms of the claims. Now, he also brought these claims that are discussed down here, which are contract claims. Those contract claims are the ones that he's being allowed to amend, and we're going to talk about that in a second. Here's a little visual that I made. I'm not going to read the whole thing. You can pause the video, you can save this, you can read it later, but there's two gigantic blunders that Justin Baldoni's legal team made. Number one, you can't claim that statements made in a complaint that's filed with the court is defamation, because those statements are absolutely privileged. And that's what they essentially allege, and the court agreed that's not defamation, it's privileged. The second blunder they made was suing the New York Times by saying that, hey, you guys republished Blake Lively's statements that were made in the complaint. Well, the New York Times doesn't know that the statements are false. They're merely reporting what's in the lawsuit. So you can't sue someone for reporting what's in a lawsuit. That got kicked as well. There's other defenses, I'll let you read it here, but bottom line, Baldoni's going to have an opportunity to amend 4 counts that stay, and those are the contract claims that are amended and discussed above here. He has until June 23rd to file those amendments and to save those contract claims, but the defamation claims are absolutely gone. I also don't think it was a good idea for Justin Baldoni's lawyer to get on the news and say that Lively's celebrating a false victory. No, bro, those claims got kicked. It's not a false victory. They won them fair and square.